Hello friends, today we are going to discuss section 12 of Law of Evidence. This is a very small section, and as usual we will first of all see what is the Barrack provision regarding it. Then we will try to decode it. Then we will see the meaning of certain terms which have been used in this section, one of which is damage and another is determine. Then we will see how section 12 is dependent upon the nature of action which is before the court. So if we see the Barrack provision of section 12, it states in suits for damage, facts tending to enable court to determine amount are relevant. In suits in which damages are claimed, any fact which enable the court to determine the amount of damage which ought to be awarded is relevant. So this is what is the Barrack provision. Now we will try to decode as to what is said in section 12. So what section 12 says that in case if it is a suit in which for certain act damages are being claimed by one party, then any fact which will enable the court to determine the amount of damage which ought to be given, which ought to be awarded, will be relevant as such. So this section enables the court to admit any fact which will help it to determine the amounts of damage which ought to be awarded to a party. Now, what is the meaning of the term damage, or in what sense the term damage have been used? So generally in section 12, the word damage have been used in sense of pecuniary satisfaction, that is monetary satisfaction. So which pecuniary satisfaction which the plaintiff may obtain if he succeeds in his action. So damage here basically means the monetary compensation or pecuniary satisfaction which is sought by the one party. Then what is the meaning of word determine? So the meaning of word determine here in this context is anything which has a tendency either to increase or diminish the amount of damage. So for example, if the plaintiff asks for rupees 10,000, then any fact which can be given by defendant that it's not 10,000, rather it's only 8,000 will be relevant. Then it will also depend upon that what kind of facts will be relevant. So the kinds of facts which will be relevant or admissible under this section will depend upon the nature of action. For example, if the nature of action is suit for breach of contract, then in that case the intention of defaulting party will be relevant. But if the same suit is for any tortious action, then generally the intention of the defaulting party would not be relevant. I would just like to give you one example that in an action for libel, the other defamatory statement, that is, in case of libel, there is already a defamatory statement which is under which is being contested by the parties. Then other defamatory statement made by defendant, whether before or after the commencement of suit, are admissible, which has a tendency to enhance the amount of damage that has been sought by the plaintiff. So this is all about section 12. We'll just have a quick recap of what all we have studied. So we saw that section 12, what it says is that if it is a suit and in suit damage is being claimed, then any fact which helps us to determine whether that is which has a tendency to increase or tendency to diminish the amount of damage will be relevant. Now damage means pecuniary satisfaction which is sought by the one party, and determine means anything which has a tendency to increase or diminish the damage. And any fact here means the certain kinds of facts which are relevant, and that kind of facts will depend upon the nature of action. If the nature of action is such that intention is relevant, then that will be admissible. But if the nature of action is such that intentions are not relevant, then that would not be admissible as such. Thank you, friends.